A significant thing, a substantive thing, though, deals with dual agency. As you know, in a real estate transaction, usually there's one real estate agent representing the seller and one representing the buyer. But it is also perfectly legal for the same agent to represent buyer and seller. Obviously, we attorneys can't represent plaintiff and defendant, but real estate agents can represent buyers and sellers in the same transaction. One thing that happened last year is there was a Supreme Court case called Haruki versus Coldwell Banker, which established what we already always suspected, which is if two different agents in the same company, one is representing the seller, one's representing the buyer, obviously the company, let's say Coldwell Banker, is representing both. But the Supreme Court decided in this case that not only the brokerage, but both individual agents are completely dual agents and have a fiduciary duty to both sides. If you talk to the average realtor before this case, they would have said, well, I'm sort of the seller's agent, and she isn't the buyer's agent, and our broker is representing both, but I have more loyalty to the seller, and she has more loyalty to the buyer. Well, that's not the case anymore. If one company has agents working on each side, both of those agents, as well as the company, are dual agents, have fiduciary duty to both sides. Okay. As that is background, a difficulty for dual agency, which I've recognized, I'm sure you recognized, just thinking about it, is when you're representing a buyer and a seller in a real estate transaction, you have a fiduciary duty to both. Those fiduciary duties may conflict. For example, what if your seller says, okay, I won't go a cent below $800,000, and the buyer says, I won't pay more than $825,000. Obviously, your seller would love to know what your buyer just told them, and your buyer would love to know what your seller just told them. What do? Well, the Civil Code all these years has actually addressed that issue and said in that circumstance, when you're a dual agent, you don't disclose it to either one. But it only dealt with that issue. What about other issues? What if you're representing as a broker, a buyer and a seller, and the seller, your seller client or your buyer client shares with you their motivations, or the fact that my wife was just transferred to Texas, I have to close in a week, I'll do whatever the buyer wants. Wouldn't your buyer client love to know what your seller client just told you along those lines? And after all, as a fiduciary, you have a responsibility to your client to disclose all facts materially affecting their interests in this transaction. Clearly, it would be material to know that the person I'm negotiating with has this particular motivation or personal situation or financial situation. On the other hand, you have also a fiduciary duty to both clients of confidentiality, to keep confidential things they tell you in confidence. There's always been a conflict with that. For 30 years, I've been telling real estate agents, when you're representing both sides, you should probably tell each side, don't tell me anything you don't want the other one to know. Because that's sort of a real problem. Well, guess what? The new law, which is also reflected on the agency disclosure form, addresses this and basically says when you're a dual agent, if either client shares with you motivation, personal financial situation, personal information, anything else that may affect the negotiation on price, you do not have to disclose it to the other one. So the law actually stepped in and said, when you are a dual agent, confidentiality wins. When there's this dispute between your duty of confidentiality to one client and your duty of full disclosure to the other. A lot of people think that real estate brokers shouldn't be allowed to represent both sides. Do you know there are many states in this country where you can't? Do you know in the entire country of Canada, if you're a real estate agent, you can't sell your own listing, you can't represent the seller or the buyer, or no one in your firm can. But it's legal in California. At least it is perhaps somewhat easier based on what I just told you. And this what I just said is reflected in the agency disclosure form that is required that brokers give to their sellers and their buyers in all real estate transactions. Another thing that was dealt with in this new legislation dealing with disclosures, and this only applies to sales of residential 1 to 4 property. When a seller sells 1 to 4 property, they are required to fill out a statutory form called the Transfer Disclosure Statement. Both the seller's agent and the buyer's agent are also supposed to sign this form. Okay. Delivery of the transfer disclosure statement to the buyer gives the buyer a right of rescission. In other words, until a certain amount of time has passed after they've received it, they can just rescind the deal. How long do they have? Well, the law has always said if you deliver the transfer disclosure statement to the buyer personally, they have 3 days. If you mail it to them in the U.S. mail, it's 5 days. For years, realtors have done neither of those things. Realtors send these things electronically, which leads to the question is it even legal to deliver a disclosure electronically? And number two, how much of a right of rescission does the buyer have after receiving it electronically? Those issues were finally resolved. The answer is yes, you can deliver the disclosure electronically, and the buyer has a 5-day right of rescission, after which they can walk away from the deal. Now, usually in a real estate residential transaction, if they use the purchase contract, this California Association of Realtors purchase contract, the buyer has typically 17 days to investigate the property, and their offer is contingent on their approval of their investigation. And typically, the standard number is they have 17 days to remove those contingencies. So often, usually, good agents give this disclosure form to the buyer long before that. So the buyer's statutory 5-day right of rescission ends before their contractual 17 days where they have to remove their contingency. But not always. Sometimes that contingency period is negotiated to a lower number, shorter number, and sometimes the agents just are late providing the disclosure form to the buyer, so that this right of rescission actually is important and makes a difference. Another question is, okay, the transfer disclosure statement is completed by the seller, and then it's completed by the seller's agent, and then it's delivered to the buyer's agent. And then the buyer's agent delivers it to the buyer. The question is, what constitutes receipt by the buyer subject to their right of rescission begins? Never really clear, now it's clear. The answer is when it's delivered to the buyer's agent, the buyer's real estate agent, that's when the clock begins. So the buyer's agent cannot deliberately extend their client's right of cancellation by taking their time delivering the form to their client. When the agent receives it, the clock begins. Which leads to another related question is, if the transfer disclosure statement is signed by the seller's agent, the seller, and then the buyer's agent, when is it complete? Once again, if you think about it, if it's not complete until the buyer's agent signs it, the buyer's agent has an incentive to delay their signature, thereby extending their client's right to cancel, which would obviously be in their client's interest. The legislation makes clear that even though the statutory form has a place for the buyer's agent to sign, the form is considered complete for purposes of this right of cancellation when it is signed by the seller and the listing agent. So in other words, seller completes it, signs it, listing agent adds their disclosures based on their reasonably diligent visual inspection of the property, submits that to the buyer's agent, the form is done, the right of rescission period has begun.